$6 million, and the attorney said, oh, it's not worth the headache? Are you out of your mind? Hi, Jeff Mersace, the Plain English Attorney, and welcome to the video. And today we're going to talk about what are the best ways to avoid probate, and we're going to respond to a Reddit thread in r/estate planning to see what some other attorneys think at the same time. I end up giving my opinion at the end. So, revocable trust versus transfer on death and POA for property. Respond to this argument. There is no need to create a revocable trust and transfer my property into the revocable trust. Instead, I can A, file a transfer on death for my home and bank accounts, beneficiaries for other accounts, and then give my agent power of attorney for property to manage my home, sell it if my agent thinks it's best, etc. The TOD and POA does away with the need to create and fund a revocable trust. All right, just initial response. That is a bad idea. It's like, I usually say these are duct tape solutions, but this is just like trying to build a car out of duct tape rather than buying a car. So let's go a little further in here. Oh, so much potential for mess here. 1, if you change your estate plan, desire, death of a beneficiary, etc., you then need to update every single account, deed, etc. 2, even if you don't change your plan, you don't actually know who your beneficiaries are until you die. Predeceased, die in common accident, afterborn children, etc. You also don't know what position your beneficiaries are in at the time they inherit and whether receiving assets outright immediately is in their best interest. Substance abuse, disability, bankruptcy, etc. And I'm just going to add age there. 3, you need liquidity after you die so debts can be settled, final taxes paid, etc. POD/TOD causes far more problems than it solves most of the time. This is not to say everyone needs a revocable trust, but trying to do everything with POD/TOD is not great. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Definitely agree with that. There are some circumstances where when you're working with a revocable trust and in combination there's some transfer on death for a specific reason. And usually that has more to do with either taxes or the way accounts have to get changed when you're talking about bank accounts that may have a lot of auto drafts. I talk a little bit about that in my trust funding course, and there's the trust funding webinar. That's a free one to take a look at. Sometimes it makes sense, but not as your whole plan. Like I said, it's duct tape. So let's go on to the next one. I agree that this is a way that you could achieve probate avoidance without a revocable trust. For some individuals, this may be a better alternative because it's cheaper than setting up a revocable trust. Here's some pushback for why a revocable trust is still preferable for some individuals, even if basically everything could pass as a matter of law. First, it may be easier to have all assets titled under the trust for organizational purposes. If the grantor wants to change beneficiaries, they need only amend the trust, not make the change for each individual asset. Additionally, a trust allows for much more flexibility and varied terms regarding successor beneficiaries, dividing up each asset, etc. Second, if the individual does not want his or her assets to pass outright to his or her beneficiaries upon death, then obviously a revocable trust allows for subtrusts for the beneficiaries. Example, age 30 trusts for grandchildren. Additionally, revocable trusts allow for tax planning that goes beyond relying on portability of the unified credit. That's a whole other thing. Revocable trust can also provide asset protection for the post-death beneficiaries. Third, Some states might not allow you to put a transfer on death beneficiary onto a home without certain difficulties. A transfer of a remainder interest in the home to a beneficiary could be subject to a recording tax or a gift transfer tax. Additionally, if there is a mortgage on the home, a transfer of a remainder interest in the home could cause the acceleration clause of a mortgage to come into effect. A transfer of a mortgaged home into a revocable trust will not activate the acceleration clause under the Garn-St. Germain Act. And that's a very big one for a lot of my clients. They're concerned, oh, if I put my house into my trust, is it going to affect the mortgage? No, it's not. Specifically, if the trust and the people on the mortgage are the same people in the same percentage, there's federal law for most properties prohibiting the due on sale clause from being enacted. So let's go on to the next one. I'll second this. A revocable trust is not necessary for every client. If they have a few assets and can pass outside of probate by TOD, POD, that can certainly work. I'm in a state with enhanced life estate deeds, so we regularly have clients that decide against a trust. I too prefer a trust to address the myriad of contingencies that can occur, but we don't push them on clients when they prefer not to have one. It's not always needed. And that's true. We can only, as attorneys, provide education for our clients, give them materials, but in the end, they need to make their own decisions. Now, I've seen a lot of disasters happen if they just kind of want to go cheap and they're not really looking at the logic of what we're talking about as applied to their situation. It could end up becoming a great big mess. And I tell them about these instances. And if it doesn't persuade them, that's fine. Stick with what the client wants to do. Another one, this is all well and good, but my experience with the estate planning attorney didn't involve any of that planning. So now we have beneficiaries in retirement accounts, POD on some bank accounts, and no idea of partial cost basis bump for one of the tax grantors or implications for the beneficiaries. It appeared more like using a template to fill in our information. How does one put together a team of tax accountants and trust attorneys to coordinate all of that? Well, this doesn't sound like it's revocable trust versus TOD and power of attorney. It sounds like you didn't get a good background and an attorney that's going to look too deeply into your situation, not the techniques themselves. It was the attorney. Then you had a bad attorney draft the documents. A good attorney will discuss all of this and make recommendations. Retirement accounts cannot be transferred into the trust, but a trust can be the beneficiary. So that's another thing to be discussed, especially in light of the Secure Act. And that's true. Again, retirement accounts are 100% taxable. If they go in and hit a revocable living trust after the person's passed on, there are certain tax rules and implications that need to be explained and understood as opposed to going directly to people. But if it goes to people, you don't have the contingencies and the trustees and whatnot. Again, it's a kind of a balancing thing. What if named beneficiary predeceases you? What if you want inheritance to go into a trust? What if property passes to a minor? All very good questions, and that's one of the regular posters on here. All of those contingencies aren't handled with just POD. Now, I'm going to note something here. So far, nobody's talked about the property power of attorney. I'm going to mention this here. It's because a property power of attorney ceases to be effective when you die. You can't have somebody get power of attorney who represents you to go out and be able to make transfers and gifts and move all this stuff after you're dead, because legally, if you're dead, you can't do any of those actions. It has to go through the probate court if it's not already titled or POD in some other way. So if it's in the trust, well, okay, no probate, no problem. If it's in your name, then we're talking probate. You're getting lots of great answers about death considerations, but I'm just as concerned about life ones. One of the benefits of an LT is today, during your life, by having additional incapacity protection for assets funded into the trust before ever looking to the POA. Instead, the successor trustee simply manages the assets for the incapacitated person. Between a POA and a trust is much harder to fail. POAs fail every single day, most especially when there are no more agents willing or able to serve. Without an agent, the consequence is guardianship, as if you had no incapacity plan at all. A failure in trustee succession, however, does not void the plan. It only requires a new trustee be appointed, sometimes with a court process. A trust is never an alternative to a POA, but when one is already in place for death protection, it's silly to throw away all the life protection that comes with it. TOD deeds are great tools, even with trusts, and especially when managing other concerns like mortgage encumbrances on second properties. But all things equal, if a property can move to the trust today, and there are no advantages to keeping the property out of the trust, e.g. that mortgage scenario, then I always prefer moving the asset into the trust today. Other big exceptions include life insurance annuities and qualified retirement accounts. Now, in all of those cases, that's exactly right, because there can be some tax implications, or two, there's not this history of big problems happening. Life insurance annuities, IRAs, and 401ks and other retirement accounts seem to transfer upon death pretty quickly and easily in the industry, and we don't have issues. That is not the case with certain companies that handle brokerage accounts and banks. So in those cases with life insurance and retirement accounts, it's better to have pay on death beneficiaries, but typically in coordination with the revocable trust being the overall plan. So, all excellent points. I'm also finding it increasingly common for an institution to push back against a, quote, stale POA, leaving the agent of an incapacitated principal with the choice of conservatorship or using the principal's assets to initiate an action against the institution. Both options are expensive and time-consuming and avoided by use of a trust. Exactly right. I generally assume now that POAs will fail in some fashion after 10 years. Earliest I've seen was 5 years, but after 10 years, pushback is exceedingly common. Rewriting POAs for nothing other than the passage of time alone is an infuriatingly important part of keeping incapacity planning up to date. Very true. This may also have an impact if financial institutions get bought and sold out and, well, wait a minute, this was a power of attorney that was accepted by the old bank. We're not going to accept it just because now we're going to extend it to legal, and oh well, it's old, so we're not going to deal with it. This happens all the time. Or you can only get them accepted after much yelling / hassle / threatening to sue. Trustee change is so much easier. Absolutely. I agree with many responses that one size doesn't fit all, but if I have my assets all set up with TOD/POD/ beneficiaries, everything is jointly owned now, and once The Last of Us passes, it will all be split between however many of our 3 adult children are still around. Financial accounts have beneficiaries, bank accounts have POD, our home has a TOD deed, we even have our vehicles titled with TOD designations. The only thing left is the contents of our home, which isn't enough to warrant probate. After having suffered through the probate process for my father-in-law's estate, I didn't want anything to do with probate. Our estate attorney that helped us set up and maintain our wills, and who also helped us with the father-in-law's probate, recommended we avoid the trust option. Said our $6 million estate was simple enough that it didn't warrant the added headache and expense of a trust. $6 million, and the attorney said, oh, it's not worth the headache? Are you out of your mind? Might not be an option in every state, but this seems like a very simple, easy approach that works in my state. All right, let me tell you that if you've ever seen any of the more recent Spider-Man movies, there's this one scene, I think it's the boat's falling apart, and he's got the webs shooting, and he's trying to pull all them in, and the webs snap every now and then. And okay, it's one of the points that was made. If you make one thing happens, you have to change everything. What if one of your kids gets into a car accident and now they're disabled and they're on Medicaid and you have them set up as their beneficiary? If you die, they're getting that money and they're getting cut off their benefits. That won't happen with the good revocable living trust. And this is where I put in my 2 cents. All excellent points, and I have a few more to add on the practical end of things. Avoiding probate is the usual estate planning goal of a revocable living trust, and this also includes conservatorship if someone becomes incapacitated. Accounts with TODs and PODs don't avoid this, but that's where a power of attorney comes in. The problem of stale POAs has already been mentioned, but I have increasingly seen some financial institutions refuse to honor a valid power of attorney because it, quote, wasn't done on their form. Yeah, so you could have a very recent power of attorney, but the bank just doesn't like that you didn't do it on their form, and they end up being able to say, no, we're just not going to accept it. So in addition to having to update the PODs and TODs on each account whenever there is a change, you also need to periodically check to make sure the bank or investment firm will accept your power of attorney if anything happens to you. On the other hand, once the account is accepted as being owned by the trust, there are no further estate planning changes needed on the account. Another issue with using TOD and POD to avoid probate is that certain banks and financial institutions are requiring letters testamentary and other paperwork to release the account to the beneficiaries. So now, to avoid probate, these financial institutions are actually requiring paperwork from the probate court. There is one institution, I'm not going to say which one it is because they're otherwise pretty good. They are absolutely horrible with this. They intentionally go and tell their clients, oh, you don't need a revocable trust because all of our accounts are beneficiary driven. And so when you pass on, they go, oh, yeah, they just need to come to us. And here are the things we need. We need this form filled out. We need a death certificate. We need their form of identification. We need letters testamentary from the probate court. Whoa, wait. You're telling us that we can avoid probate by doing this. We don't need a trust. But you're requiring letters from the court. Oh, well, yeah, it's just that's something we need. Okay. I don't care about any technicalities. Well, technically it's not in probate because it had a POD on it, but you still have to go and deal with the court to get those papers in order to send it in and then probably put it on a damn inventory and have it filed. And if the court doesn't like something, then they can drag it and pull it. No! Don't stop lying to people. In fact, I called the video that I did on this previously the big probate lie. No. Put it in the trust. The worst offender is simultaneously telling the clients they don't need a trust, right? I haven't seen any issues with needing probate court paperwork to release control to the successor trustee. It's true that there are some cases where a trust is not needed and POD and TOD beneficiary designations are good enough. However, in a lot of cases, the drawbacks and potential complications make a trust a better option. And that's really where it's laying. I have some clients, it's their parent, maybe they're even living with their child, they just have their bank account, maybe a retirement account, and that's really it. So there isn't an awful lot that needs to be done. You don't need a revocable trust in that situation. But one of the previous posts is, oh yeah, we've got $6 million worth of stuff. Our attorney said you don't need a trust. Okay, I'd really like to see the makeup of what those assets are, but very likely that would have been a much better case for a revocable living trust. So, yeah, you've got all these things, POD, you've got a power of attorney, but you've got a trust. And when it comes to avoiding probate, the trust is probably the best way to go. We've got other tools and resources on my law firm's website at livingtrustlawfirm.com. Go ahead and check it out. And I already mentioned that we've got some free webinars, including one on trust funding, which talks a little bit about some of the disasters that happened when a trust isn't properly funded, and there's a full trust funding course as well. So I hope you found that information useful. Please like, subscribe, turn on the notifications so you can get this really good information, and it helps us out by spreading the word. So if you want to keep this information out there free and available, then please help us out by subscribing. So as I tell all my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.